Do I have a pretrial on this?
Yes, please.
Where's Mr. Corey? This is the co-defendant on the other. I just need the DA.
Okay. I'm looking for co-counsel, but I guess that was already disposed of.
Well, it was, they selected a bench trial and they had a motion to dismiss on De Benedetto, so, but I need the DA, so let me give you a further call on
We're
this.
trying to get him in right now.
All right, if he comes in right now, we'll do it right now.
My apologies, Your Honor.
That's okay. Where are we at with discovery on this case?
Your Honor,
I know you filed a bill of particulars, but other than that,
I reviewed the Commonwealth Certificate of Compliance, and while it deals with some things that we certainly have received, it seems to me that there are matters that are part of the Commonwealth's prospective elements of proof that aren't included in the discovery.
such as,
An element of the statute is that another person other than the defendant had lawful custody of the child. And that is something that would require some sort of proof of lawful custody. It's not something, I don't even think that a witness could testify to.
well, let me ask you this, counsel, if there's a court order giving DCF custody, isn't that prima facie evidence that someone else has custody?
Yes, but it's gotta be at the time of the.
No, I understand, but I assume, and I'm not presuming anything, but I assume that if there's a court order, it's gonna be dated and signed by a judge.
And I agree with you.
Okay.
And that hasn't been provided, among other things.
Okay,
Now, what I'd like, I'm new on the case, but what I can do, and I can do it fairly readily, is provide what I call a notice of discovery compliance, and which basically lists out for the prosecution all the things that we expect or intend to get. It's
Well-
like a checklist.
but that's different from what they're required to provide, isn't it?
I'll make it as, I'll adhere to Rule 14 as much as I possibly can. If they think that
Well,
I'm
no, not
out-
as much as you possibly can, it's, you'll adhere to Rule 14.
Well, yes.
Okay,
And if they think that I'm not adhering, then they can
But-
bring that to my
I know,
attention
but
and resolve it.
I'm trying to streamline this process, not to rush anybody. But I just wanna make sure that everyone's expectations are along the lines of what the court expectations are, and so you need to, was the court order provided?
No, I don't have a copy either, but you can go up, I'm sure you can get it from the courts, either of us would.
I never got one
Well,
either.
Well, sir, anything you say here, just so you're aware of, is being recorded, and you certainly don't wanna say anything that could later on be used. You can get that.
I'm not sure, that's a juvenile court, everything's
Except your client's a party to it,
everything's
and he's
impounded.
a parent.
I don't represent him there.
No, sir, you have a lawyer.
In any
If you
event,
draft an order, sir, I'll allow it. Please.
don't say anything.
If you draft an order for the juvenile records, I'll allow it.
Yes,
For the court order.
but this is shifting a burden
No,
that
it's
the
not.
Commonwealth bears upon me. They have a burden of proof in the case to put on evidence, and that evidence in the discovery rules are that they have to provide it to me. I don't have to make their case for them.
No, I understand that, but this information is as readily available to you as it is to them. And when it goes to trial, obviously he's gonna need the court order that says that your client doesn't have custody.
Oh,
In other words, counsel, I don't think it's the Commonwealth's they have an obligation to provide discovery. But they don't have an obligation to spoon feed the defense.
true,
Okay,
but their discovery obligation includes, under Rule 14, all documents that they intend to introduce at trial.
I don't disagree.
So if I don't.
So what do you say is outstanding? The court order.
The court order certainly.
What else is outstanding?
Any proof of service of such a court order?
What if it's testimonial?
That would be a witness statement.
Okay, what else?
The, well, what else could depend upon how this is particularized?
No, I understand. I think it's easier to just speak in plain language now so that when everybody leaves here, they know what their obligation is, that's all.
Well, I would say, certainly broaden my document request to any documents the
But
prosecution.
you haven't filed a document request, have you? You filed a notice of bill of particulars.
That's true. However, Rule 14,
I understand that, but you just mentioned document requests, and I can't rule on a hypothetical motion or document request that has not been filed.
I think that you can. Let me proffer how you might go about doing it. Rule 14 says, any documents the Commonwealth intends to introduce at the trial of this matter. That is what I'd be
I'm
looking
confident
for.
Mr. Corey's aware of his obligation.
Okay.
Okay.
Just so that we're clear on that.
Yeah.
That if I don't receive any documents that they seek to introduce at trial could be excluded.
Depending on how the judge rules, but again, if you file a motion for exactly what you want, counsel, I think it would be a lot easier.
I'll gladly do so, and I'll do so expeditiously.
Where are we at with this? So those two things you need.
Yes, that and, I don't know, the Commonwealth hasn't taken a position in the particularization.
What do you say about the defendant's motion for bill of particulars?
I haven't even seen it.
Did you give it to the Commonwealth?
We did, we served it, but I have extra copies here.
All right.
I see that you have it in front of
I
you.
do, cause it's been filed with the court on
Yes.
August 18th.
Yeah, it should.
But what is, and it says certificate of service, I hereby certify, true copy, was served upon the DA's office by mail.
Probably just sent to the general, it just hasn't reached me yet.
Okay.
Sure.
Any objection?
No.
All right, it's allowed by agreement. What's the next step, counsel?
The co-defendant, if I may inquire, what date,
They get September 23rd for bench trial.
I suppose since they're going to a bench trial, there's not a great need to keep us together at this point?
Well, the only need, and I guess it's not a need, is that I know the prosecutor will be here on that day.
Well, that's,
And I don't know whether or not that day is available for you, counsel.
I'll take a quick look if I may.
Sure.
As fate would have it, I am available that day.
Perfect. You wanna put it on for that same day for compliance?
That would be fine, and well prior to that date, I will send what.
Do you have the prosecutor's phone number and his email and an ability to communicate directly with him?
I don't believe so. We just use what was in the red book.
No, I appreciate that, but before you leave here today, can you exchange contact information from the prosecutor, and that way, when there are motions filed, if you could send it directly to him, it's a much better way of dealing with these.
Absolutely.
I appreciate that. All right. I will see you on September 23rd, sir. I'll see you on September 23rd, okay?
Okay.
All right, you have a great day, sir.
You too, sir.
Take care.
Take
Thank
care.
you, counsel.
Melanie Russell.
Judge, that's my matter. We're discussing a resolution to the case. If we could have a second call,
Sure,
please.
second call.
Courage Yancey.
Judge, she is present.